My name is Megan Quinn. I work with a firm called Ellerby Thompson, Sapp Wilson, and I've been there since earlier this year, moved from a different firm, and I do labor and employment almost exclusively with some complex business litigation. So mostly your normal Title VIIs, some FLSAs, class actions, just kind of your run-of-the-mill labor and employment cases with always some interesting fact patterns behind it. All right, so as you are aware, this presentation is going to walk through the different steps of an investigation. So how to conduct an investigation. I'll point out common missteps and things that people don't always think about when they do not regularly conduct these kind of investigations. So we've got a lot to get through in a relatively short amount of time. So I will try to speed through the slides that seem fairly self-explanatory. And but if you have questions, if you think I skipped something, please feel free to ask a question. All right. So the first ground thing is obviously the last thing you want to do when conducting investigations is to start there without any policies. This presentation and kind of where we're starting assumes that you already have anti-harassment policies and that you have not only developed those but disseminated those to your managers and supervisors and employees. So that's kind of the ground level that we're working with. And the reason why that is because going into an investigation, you obviously need to be concerned about some civil liability on the employer's part. And the major liability issues there have to do with harassment, discrimination, and retaliation claims. Courts look at prevention, so whether or not you have policies, adequate policies, and if you've informed all of your employees about those policies. Detection, so if you have made sure to have reporting procedures and that you listen to those reporting procedures to complaints that come in and have an adequate way of responding to them. And then remedy, how you respond to complaints. You know, if you have great reporting procedures, but at the end of the day, nobody ever is disciplined, nobody is ever terminated, regardless of how egregious their behavior, then all of those policies and groundwork that you've laid is pretty ineffective. So beyond those normal kind of Title VII, ADA, FMLA claims, you also have negative retention claims, which under Georgia law, if as an employer you knew or had reason to know with you know a reasonable amount of due diligence, you would have learned that an employee had a potential to harm a third party. The employer can be held civilly liable. So as an example of that, if someone complained, another employee complains that, hey, this driver, I think I've seen him drink during lunch and then get back in the car. And you don't conduct an investigation. And then later on, that driver gets in an accident where alcohol plays a part. That's where you get into negligent retention. So the idea that the employer should or could have been aware of this potential harm. And then, of course, because we're talking about local governments, we've got agency liability, which is under 42 USC 1983, the liability of governmental agencies if there is a policy, custom, or practice of authorizing, condoning, or tolerating alleged unlawful conduct. So that means, you have a policy that uses excessive force, those kind of claims. And then beyond just the legal aspect, whether or not the employer can be held liable. On the more personal side for these kind of investigations, you are looking at, employee morale, retention and recruitment. Obviously, it's hard to keep employees if they don't feel listened to or they feel harassed or discriminated against. And then safeguarding on the PR aspect, negative publicity. And so those are kind of all your concerns for why it is important to be committed to having a good harassment and discrimination investigation technique. All right, so the first step is selecting appropriate investigators. And kind of playing into what I was talking about before, the last thing you want to do is have your investigators select investigators at the start of a complaint. It would be helpful if you have, before this point of selecting investigators for a specific complaint, you've trained some. Maybe your HR department or managers that are over a specific group or supervise a large agency or department. It would be good to walk some of those people that you think are potential investigators through the process, maybe have them do some mock-ups, some practice, so that when you throw them into an actual investigation, they aren't looking at these slides just trying to get their feet wet at that moment. But when you are selecting investigators for a specific investigation, you want to look at conflicts of interest, and that's whether actual or perceived. Perception is reality. So if everyone thinks that I am best friends with the respondent, with the person who's accused of acting improperly, it doesn't matter if I actually don't know him from anyone else. If the perception is there, I am not a good selection for an investigator. And then, depending on the complexity of the complaint, I was recently called in to conduct an investigation where it wasn't so much that all the complaints were complex. There's simple ones of, and sometimes very petty ones of, he doesn't say hi to me, or my supervisor doesn't treat me the same as everyone else. But in this case, because there were so many complaints within one department, the employer decided that it needed an outside investigator, that clearly there were a lot of issues that were bubbling under the surface that were causing people to file 10, 15 complaints. And that's when you might want to consider whether or not you need someone, an impartial person outside of the agency to conduct the investigation. And then also respective workloads. Don't choose an investigator who's so underwater that they're not going to be able to conduct a prompt and effective investigation. Not working. All right. And so you need both a prompt investigation and an effective one. So an investigation takes some preparation. You need to read or investigate the complaint a little bit, find out some stuff. Maybe you need to go through personnel files or past complaints, and you need to write up some outlines to make sure that you're getting the information that you need. So there's some legwork that goes into an investigation before you start doing the interviews. So even though you want to be prompt as possible, that does not mean that you let the legwork, the homework slide before you go into your interviews. So it's about balancing that need. But what you can do, what helps often, is to inform the complainant that the complaint was received, that you're reviewing it, and that an investigation will be conducted. And that way the complainant knows, at least off the bat, even if an interview doesn't happen for, say, a week, that there is something happening, that there's not just, yelling into empty silence. And during that time, during the investigation, before you can make findings, you want to consider interim remedial measures. So that means, particularly when a complainant and a respondent work in close quarters, whether or not you can, rearrange shifts or relocate. Certainly, an administrative leave of absence is a possibility. In that sense, you need to emphasize that it's non-disciplinary and that it is with pay and benefits. Absence, very, very extraordinary circumstances, leave should be with full pay and benefits. And the more important thing, or not more important thing, but one thing to really consider is that if you are going to take some measures and someone is going to be inconvenienced, someone is going to have their shift changed, it should be the respondent, not the complainant, because here you have retaliation concerns. So if you switch someone from a day shift to a night shift, and they could allege that that is retaliation against filing their complaint. All right. Of course, your next step is for your investigator to identify the issues to be investigated. So that means obviously what has been alleged in the complaint, any other relevant documents that will give you some more insight. Now, that doesn't mean that you can't investigate things that come up during the investigation. If you are investigating an allegation of sexual harassment, and it comes out that the respondent not only says things that are inappropriate of a sexual manner, but also says things that are inappropriate, makes racial comments that are inappropriate. That doesn't mean you can't investigate that. Certainly you should. It's an offshoot. It's a natural offshoot of that investigation. But the key here is to not spread your net so wide, that you are spread too thin. It's ineffective. So focus on the key facts, the key complaints. Certainly investigate the offshoots of those that are natural, but make sure that you remain focused on what the complainant is actually complaining about. All right. Now, this goes back to choosing your appropriate investigator. So if the investigator needs to be familiar with the policy, procedures, standard operating procedures, because if they're not, something could sound, someone could allege something and that could sound inappropriate, but it turns out under the policies of this department, that is appropriate. So if someone, for example, is alleging, well, the director of the department never says, never responds to my emails. And, it turns out under the standard operating procedures, they're supposed to go to their manager first and then the director. That means that under the procedures, the director is acting appropriately. So maybe that's something at the end of the day that you'll decide maybe that's not the best procedure, but under the procedures, they're acting appropriately. And that's something that you need to know and be able to kind of have a dialogue with the complainant. Because if the complainant's not aware of those procedures, that's also another part of your investigation. So again, be aware of all the applicable procedures, policies, and make sure that the investigator that you choose is aware of them. All right. So the order of the interviews. This is a little bit flexible. So the first one is 99.9% of the time the complainant. So that means that you want to fully flesh out what the complaint is. Sometimes someone submits a written complaint, and because not everyone is a linear thinker, it's all over the board. You can't tell when things happened or where they were alleged to have happened. So that is why interviewing the complainant is the first step. Now, people differ on what's next. You can interview witnesses, Certainly interviewing employees, current employees, is easier than tracking down former employees or people who were never employees to begin with. It is, for obvious reasons, harder to get those people to come in and cooperate with an investigation. And then you can interview the respondent. Depending on the complaint, you might want to go with the respondent first or second after the complainant. But most of the time I leave the respondent till the end, because that way you can hear, you know, a theoretically impartial third party's take on what happened before hearing what the respondent said. Because otherwise you just get a he said, she said, with a complainant with one version and a respondent with the other, and you're not quite sure what's in between. Whereas with an employee witness or a former employee, a witness interview, you then can say, well, you also, we have other people who say that you did this, and that helps flesh out the interview with the respondent. And of course, you have always the ability to follow up on interviews. So if, you know, the complainant said one thing and an employee witness says, well, I don't quite remember it that way, you can go back to the complainant and follow up, flesh it out, see if there's something you missed, see if there's something you misunderstood, and that always helps. Like, never be afraid to go back to re-interview or question an interviewee. Right. Now, the next step, or honestly, probably before conducting interviews, you want to secure everything. And so the obvious things are, you know, paper documents, electronic documents, any videos, if there's video surveillance. A lot of those systems, you know, rewrite themselves every 5, 10, 30 days. So if there is something that is pertinent, you want to secure that right away. Audio recordings, voicemails, those are often deleted on a pretty regular basis. You know, a lot of employers have retention policies that, you know, say within 60 days things are going to disappear. You want to secure all of that. Make sure you have it well before you run the risk of timing out. And then misplaced things. Okay. Okay. And so to go with this, the other idea here is not only do you want to secure things, but you want to be aware of chain of custody. And so that's a term that we tend to think of in a very legal sense, but just be mindful that, you know, that things can be doctored, things can be fraudulently made, certainly as technology goes forward. So it's just better to have the least number of people touching things, to get it from the source, and to make sure that you have it secured in some way, because it just locks everything down. Okay, and then, okay, so also consider your tools that you can supplement an investigation with. So you've already been doing your document review, your review of all pertinent videos, documents, everything like that. You're conducting interviews. And depending on what the allegations are, some other things might be relevant. A drug test, drug or alcohol test, you know, if someone is making allegations that someone is, you know, under the influence on the job, certainly that could be appropriate. Search of a locker, a desk, and a vehicle. With that, you do want to consider privacy concerns. So, for example, you know, I've got vehicle search on here, but a vehicle search of a employer-owned vehicle is one thing. A vehicle search of a private employee's vehicle is very different. So, obviously, if it's employer-owned, much less of a privacy concern versus employee-owned. And then forensic computer expert. This will depend on how developed your own IT department is. If you're small and you run by, Bob knows computers pretty well, so don't have him do it. If you've got a good IT department who is capable of going through emails and stuff like that, then that may be great. Certainly if you can take, if the allegation is something like sending inappropriate emails, taking a snapshot of someone's mailbox, email account, might be a good idea, so that you know that as of, September 21st, 2019, this is what their mailbox looked like. And so that way you can have that, you can search through it, but nothing's going to be destroyed or deleted. And also with particularly forensic computer experts, they can go and see if anything's been deleted. So if we're talking, deletion of important documents, or depending on how important the emails or other documents are to the allegations, certainly if the allegations solely stem about inappropriate email or other electronic communications, an actual outside forensic computer expert may be necessary. And then these are additional things that you can do, look at cell phone records. So the adverse inference rule that I have listed down here, that means that's more of a court rule, but it's something that you can consider, which is the idea that if the complainant alleges, hey, my boss sends me sexually inappropriate memes all day, every day, and normally you would think that the complainant would have, some copies of those. They don't. Then you're wondering, like, how can it be that this is happening, all day, every day, but you have none to show me? Or vice versa, if the respondent, I keep on wanting to say defendant, if the respondent just goes, you go to tell them and say, hey, this has been alleged, and they go and delete their entire inbox. That doesn't look so good. So it's less of a hard and fast rule, but it's just something to consider. It's, someone isn't able to produce evidence, or they go, it seems, to an extreme to delete evidence. All right, so you've considered, you've looked at all the documents, you have contacted or considered the order of your interviews, and before you go into an interview, you now want to prepare outlines. And I found that outlines help you stay on task. They make sure that you don't forget to ask specific questions. If you've got a complaint and you're unclear about a specific fact, you want to put that question in your outline so that when you're having this conversation, this interview, that doesn't slip through the cracks and then you're having to call them up and ask them to clarify something. Interviews really help, or outlines really help you make sure that you cover all of your bases during an interview. And you want to have specific interviews for each witness. Half the time, particularly with more third-party interviews, you can kind of pick and choose, use a template, adapt it for that person. But just make sure that you are actually going through the outline and making sure that it applies to that particular interview. And of course, the last thing that you want to consider, and always have in the back of your mind, is that every investigation has the potential to end up as part of a litigation, or administrative proceeding. So that means that you want to have clear notes. You want to make sure that you're documenting the process that you took, and how, show that it is prompt, it is thorough, it is effective, and that will help build the file for how it will eventually look in a lawsuit or administrative proceeding if it gets to that point. All right. Okay, so got those baseline steps. Now, initiating the investigations. Before you go in to your interviews, it's oftentimes good to talk to the appropriate managers. And that's because those managers and supervisors are probably going to know on some level, if you're calling employees out for a 3-hour interview, the manager or supervisor needs to be made aware, just to keep the department running. So you want to manage their expectations without telling them too much, and make sure that they are on board. And then the other thing is to get some feedback about who you're going to interview. Obviously, people who work with those interviewees are going to know them best, are going to know how they're going to react best. So maybe you want to know if there's something that the manager or supervisor has witnessed, if there's something about the personality, if you think that if the manager doesn't think that they will cooperate or thinks that they will, thinks that a particular witness will be more sympathetic to someone, the manager can tell you if Betty is best friends with the complainant and is most likely to side or give the benefit of the doubt to the complainant. Another thing is to make sure that the managers and supervisors are on board. They need to know that they have no right to refuse to cooperate with a workplace investigation. That is part of their duty, and it's part of their duty to support it. And I'd like to highlight here where it says, be sympathetic to any concerns they may have, but don't apologize. Oftentimes, managers and supervisors are thinking along the lines of, how is this going to disrupt my life? How is this going to disrupt my team's life? And that's an understandable concern. One of my go-to concerns is, I understand and I hear you, that's a valid concern, but you don't apologize. You need to conduct the investigation. It is what it is. You will do your best to have it over as promptly as possible, but there's no need to apologize. This is part of their job. Okay. All right. So coordinating witness interviews. As I said, you've got the order of it. You want to schedule them with some flexibility. So that means that schedule them with a large enough amount of time to fully flesh out the complaint or what they've seen. Sometimes people just want to be heard. So if your complainant is kind of a little bit rambly, you can certainly try to focus them, but don't end an interview. You say, I scheduled it for 2 hours, it's been 2 hours, that's enough. It's sometimes really helpful just to keep going. For example, I had an interview recently where in the written complaint, the complainant alleged gender, race, and sexual orientation discrimination. And during the interview, which went on for, I want to say 3.5 hours, it was a very long interview, where he eventually kind of on his own walked back those. He still felt like he was being mistreated by his supervisors, but on a more personal level, that that it was a personality clash, and he walked back because we were able to fully flesh out his complaint. I asked him, all the examples that he gave, and I also, asked, like, has anyone ever said anything about your race? Has anyone ever said anything about your gender? Why do you feel like you're being mistreated because of your sexual orientation? And, you know, because he wasn't able to have any specific points for those, you know, no one had said any specifically about his race, gender, or sexual orientation, and we were just talking about his interpersonal conflicts with his boss. He, you know, kind of walked by and he's like, okay, maybe it's not because of this, but it's because she doesn't like me. And that may well be, but by listening to him, by fully letting him kind of talk through and think through everything, he kind of rescinded some of the more legal term allegations. All right, and then, so this slide, I realize the order of it maybe should have been beforehand, but before you go into an interview, you want to examine work areas and other relevant sites. And that's because it can be very hard to picture something when someone's telling you, well, I walked down the hall and Cindy's to the left and Rachel's to the right, and they're telling me, and they were both screaming at me. You want to be able to picture that. You want to be able to ask questions about that. Certainly, you know, if someone says, well, I overheard them screaming at each other, and you ask them where they were, you want to be able to, in your head, picture, okay, well, that makes sense. They were, you know, 5 to 6 feet away from them, versus, oh, well, you were in a conference room, but you said that they were on the other side of the hallway. How would you have heard them? So by being familiar with the relevant sites and being able to picture things, you are able to ask more informed questions to fully flesh out what the complaint is and who and what is the most accurate picture of what happened. All right, so going into the actual witness interviews. Number 1 rule, interview everyone separately. There's no group interviews, and there's no waiting with everyone kind of gathered in a waiting room while you bring in one person at a time. Now, everything should be conducted out of sight and out of hearing and broken up, you know, as discreetly as possible. Sometimes that means off-site interviews. Sometimes that means, you know, completely separate building, whatever it is that will make it most discreet. Just, you know, if you conduct all the interviews in the conference room next to the floor where everyone sits, that is just going to become a huge gossip story, and you don't want that. That muddies the water. The less people are aware of the investigation, or at least the people who have no reason to directly know about it, the better. Okay, record or in some way each interview. This can be a little bit tricky. It's hard to write notes and also interview at the same time. I know that I am guilty of going back later and looking at my notes and saying, that is not the word that I meant to write down. But because I was trying to talk and write at the same time, sometimes things get a little mixed up. So during an interview, don't be afraid to say, hey, give me a second, I need to write this down. Or asking people to repeat things. Certainly when people get on a roll, they keep going and they don't take pauses. Some people are more naturally fast talkers. So you want to make sure that that you're taking adequate notes, that you're allowing yourself time to write everything down. And write your notes as professionally as possible, because remember, this could end up in a lawsuit or an administrative proceeding. And even for your own sake, I mean, the last thing you want to do is you're trying to make findings at the end and you can't read your own notes. So you want to be as clear as possible, write down the relevant stuff, facts and observations, not your opinions, and don't get bogged down in irrelevant details. You know, I tend to start interviews with some kind of background information, but that doesn't mean I need to write it all down. You know, if someone's telling me their long work history up till this point, I will just write down, you know, 10 years at here, previously at you know, this employer or that employer. Unless it's super relevant to the investigation, don't write down things into your notes because it's just going to bog you down. People are often inclined to audio or video record, and well, in Georgia, which is a one-party state for recordings, it means that I can record you without your consent because I've consented. But that can have a very chilling effect. So we don't recommend recording something without someone else's knowledge or consent. At least in most internal investigations. If it's highly contentious, you might want to consider it, but you certainly don't want to violate trust so that either that investigation is hindered or further investigations down the road are hindered because it gets spread around that you secretly record things. And you don't want a witness to feel clammed up. So while you can, it may not be the best method for recording an interview. And then the other option, though, is to have a co-investigator. Now, maybe one person takes notes and one person asks the questions, or maybe you both take notes and you confer at the end and hope that between the two of you, you've got everything. So both of those can help make sure that you have an accurate record of the interview. And then at the end, depending on what the investigation reveals, you can ask for a witness statement, ask if the witness would be able to sign off on the notes, some way that to note that the interviewee agrees with the notes or what was said during the interview. All right, so follow your witness outline, pretty straightforward. Like I said before, sometimes an interview will reveal things that you need to explore that you didn't know before. But for the most part, it's best to stay on your outline because it will help keep your interview to a reasonable amount of time and focus. You'll want to start by explaining the purpose of the investigation. This tends to be pretty general, particularly with third-party witnesses. You want to make sure that you're not influencing the recollection. So instead of, by general, we mean, allegations of inappropriate behavior in this department or things like that, where you are not saying person A did this to person B. It's also very helpful to ask the witness what they know, whether it's because, why they believe they're being interviewed, who's told them what, and what has been said. All that is very helpful to know. And also what they believe is most relevant. Sometimes people will volunteer things because you ask that question, because you say, why do you believe they're here? And the way that they frame it can be very helpful. So, if you say, why do you believe they're here? And they say, well, I've heard that it's because, Sandy is accusing Johnny of this, but really Sandy, accused it, also should have mentioned X. And so those can be very good by having those open-ended questions. Of course, you need to explain that in the investigation they're expected to cooperate. Explain that it's your job to fully flesh out the complaint, find out what happened. Explain that there are consequences to not only refusing to cooperate, but providing misleading or incomplete information. If someone is also a complainant, so obviously the complainant is a complainant, but if a witness says, you know, you're here because of Danny and Danny has also sexually harassed me, then you need to note that and treat that, then shift your focus so that that interview is being treated as a complainant interview. You can also, one option is to have a witness sign a written acknowledgement of their duty to cooperate. That's in verifying that the information provided during the interview is true and correct. So that whether that's necessary will depend on the investigation, but that's definitely an investigation technique and option, particularly if you're worried about someone not cooperating or not giving truthful answers. All right. Now, garrity. Garrity is something that is unique to public employers as opposed to private employers. And this is a protection that stems from the Fifth Amendment, and which declares that a government cannot compel a person to provide testimony against him or herself's own interests. So I'm going to give you a scenario. So in this scenario, an employee is accused of selling illegal drugs. Supervisor advises him that he is ordered to cooperate and that if he refuses to answer questions, he will be dismissed from his job. During the course of the interview, the employee admits that he sold drugs to a coworker. So the two questions are, can the employee be disciplined for violating policy? And this is, of course, because the selling of illegal drugs is against policy, the employer's policy. And then can the employee's admission be used against him in criminal proceedings? So the answer here is that yes, the employee can be disciplined. There's nothing wrong with that. Violated policy, that's fine. But the statements cannot be used in a criminal proceeding. And that's because the employer, the supervisor, told the employee that he had to cooperate and that he would be terminated if he didn't. So that is compelling the testimony. So by compelling the employee to talk, those statements are now excluded from a criminal proceeding. So as far as an internal investigation, they're fine, they can be used, they are, and the employer is free to use those statements to justify any discipline, but it cannot be used later in a criminal proceeding. So the bottom line here is there is nothing stopping you from compelling someone and, saying, hey, you have to cooperate with an investigation or you will be disciplined, terminated. But the idea is just that those statements cannot then be used in a criminal proceeding. And so if you are giving a garrity warning, this is an example of one, and you'll get the slides so that you'll have this. And it's just informing someone of their garrity rights. This really doesn't need to happen in most investigations. So you'll want to explore that, but it's only if criminal activity is implicated. So if it's something civil, if you're talking Title VII, you're talking sexual harassment, unless someone is claiming that there's an actual assault that happened, as opposed to comments or something like that, then garrity does not apply. Garrity would not be relevant in that case. All right. So as far as how you conduct the interview, your behavior during the investigation is very important. So it means set a professional tone, but not standoffish, not accusatory, or confrontational. So, and this really, the ease that you will be able to do this will depend on your relationship with these witnesses and how well they know you. But certainly, if you're meeting in a conference room, don't block the doorway. You know, I tend to put witnesses kind of close to a door so that they feel the need to step out. I'll tell them, hey, if you need a bathroom break or if you need water, anything like that, please let me know. So all of that kind of sets the tone that this is not an interrogation. This is not something where you are not free to leave, that this is a conversation and we're trying to figure out what happened. I want to hear your side of the story, but you are not in any way, you know, chained to this desk or this chair. And then number 4, avoid agreeing or disagreeing with witnesses during interviews. So again, this can be a little bit hard, especially if you are not used to doing investigations or you are you settle into a more conversational tone. Sometimes, you know, people in conversation give reactions back, you know, like, oh, really? Or that's weird, things like that. And you have to tone that down. You are gathering information. You are not giving a reaction to the interviewee. And consistency. So how you approach each interview should be consistent. There are some people, there's going to be a small margin of difference between each interview, just because people are going to walk into an interview differently. Some people are very defensive. Some people are very nervous. And so you will have to meld your interview technique a little bit, but depending on the emotion of the witness, but that doesn't mean that you should drastically change. So the complainant versus the respondent should each get, you know, that same, like, hey, I just would like to hear your side of the story, that kind of stuff. It shouldn't be, you know, the complainant gets, hey, I'd like to hear your side of the story, and the respondent gets, I heard that you did this, you've been accused of this, blah, blah, you know, like that. Techniques need to be fairly consistent so that you are not subconsciously putting your own bias into the interview. And of course, one huge way to put your own bias into an interview is asking leading questions. This can not only mean that you are only eliciting the information that you are specifically looking for in a way that is detrimental to the investigation, but it also means that you can influence the way someone characterizes something. So instead of asking leading questions, ask open-ended questions. So for example, if you're asking a witness something, because usually with the complainant, they know what they want to talk about. It's pretty easy to get them just started. With a witness, if you're trying to bring something up, you know, you can say, hey, do you remember, you know, on September 24th, being at a staff meeting? And if they're like, yes, you know, then that's your open-ended question. You can say, tell me about that meeting. Who was there? What happened? Is there anything memorable? You know, instead of saying, hey, at the staff meeting, did you see Jenny berate Mark? That gives a whole different color to the question versus just trying to get an open-ended answer and the take of the witness on what happened at that staff meeting. Closed questions are proper at the end of the interview. Summarizing questions. So if at the meeting, if the witness says, well, at the meeting I saw Jenny talk to Mark to the side, and they looked kind of heated, but I couldn't hear what it says. You can summarize that. You can say, okay, you saw them in a corner talking, but you did not hear what they said. And because you are summarizing what was already said, that's much better than asking a leading question and much more acceptable. And then point number 3 is going to be one of your biggest frustrations with conducting an investigation it is not our natural speaking way of speaking to be very detailed for most people. During an interview, you will get, well, yeah, you know, Jenny isn't nice to Mark. And you're like, okay, what does that mean? You know, how do you know she's not nice to Mark? What, like, you know, is it something she said? Is it something she did? Did you witness it firsthand? People have a tendency of not differentiating between what they've heard and what they have firsthand knowledge of. So you have to get very specific with your questions. You have to delve in. You have to make sure that you are actually not just taking someone's word for it, but you are getting the specifics. So, you know, it's your classic who, what, where, when, how. You know, who did you see? What did you hear? You know, ask for as verbatim. You know, if it's a phrase or something that someone is being alleged saying, ask verbatim what their memory is. You know, what do you remember specifically that this person said? You have to get specific, and with certain interviews, it will take you a long time to get there. Some people are just not great at being very specific in what they remember and how they tell a story. All right. Do not promise confidentiality. This is the manage expectations part is kind of the overarching thing, because there's no way to maintain 100% confidentiality in an internal investigation, particularly because these, you know, if you are an agency that's subject to the Open Records Act, after the close of the investigation, there could be an Open Records Act request that you have to comply with. Also, you know, the respondent's ability to have knowledge of the allegations made against him or her. If we're talking about police officers, they're, you know, as an employer, you have reporting obligations. So just do not promise confidentiality. You can say, hey, we're trying to keep this you know, on a need-to-know basis. You know, certainly, and there are later slides about this, that you want to be discreet in your investigation, but promising 100% confidentiality is a no-no. And then with your notes, when you're conducting interviews, take note of not just what is said, but how the employee is acting or the witness is acting. So, you know, inconsistent statements, not making eye contact, really pay attention to body language. You know, if someone's being defensive or someone won't look you in the eye, take note of that. Our ability to interpret that is not always the greatest, but if you note that, you can say, hey, you know, their story, they just weren't looking at me. I wonder why. And maybe that will cause you to, you know, find a different witness, see a different side to it. So note not just what is said, but also how they act and whether there are things that seem implausible in their recollection. Okay, so, and then, so as I said, you cannot promise 100% confidentiality, but you should instruct your witnesses to not discuss the investigation, the interview. You know, my go-to usually is, you know, obviously supervisor or manager will know that someone is out of the office or in an investigation, but ask that the witness not discuss the specific questions or subject matter that was brought up during the interview. You can threaten explain that there are consequences of non-compliance. Oftentimes that's pretty hard to enforce just because you don't know who's talked to who, but it is important to stress confidentiality. All right, miscellaneous considerations. Always ask a witness for other witnesses. Oftentimes, particularly if it happens in a group setting. If something happens in a group setting, somebody will remember a couple of people there, but may not remember that somebody else walked up or something like that. So it's always best to figure out if each witness has can remember anyone else that is relevant to the investigation. Ask them in an open-ended way if there's anything else that you should know. Because if you are, on your outline and you're targeting specific things, maybe there's something else that is relevant but you just haven't heard about yet. So ask a witness that. Avoid answering questions. So as I said before, with avoiding giving reactions, you are there to gather information, not to provide it. Sometimes people have questions about the investigation process, and that's fine to answer in a more general way. Say that you're conducting an investigation, you're going to make findings at the end. There'll be, you anticipate that it will take, 2 weeks to conclude, 2-3 weeks, but all of that should be on a very general level. And as far as the witness asking you specific questions about allegations or whatnot that you have not already shared, you should not do that. No right to have an attorney or other representative present for interview. This is an internal investigation. This is not a legal proceeding where they'd have a right to an attorney. And I had this recently come up where someone basically said that she would not cooperate without an attorney present. And she was told that if she decided not to cooperate, that she could be disciplined up to and including termination. And she quickly changed her mind. Let's see here. Remember, silence is an effective tool. Some people are nervous. Some people are more inclined to fill the silence. And sometimes what they say in that silence can be very informative. So do not be shy or about asking a question and just kind of letting the silence fill. I don't know and I don't recall. People can be prompted in some ways, ask them what would, if they say, oh, I don't know the date of that meeting, or I don't know if I'm thinking of the right one. Ask them like, well, do you have calendar entries? Do you have a schedule or something like that that you could check? Figure out what information those people would need to answer your questions, or help narrow things down. Like, obviously you don't want to pressure people into giving inaccurate answers, but you can have them narrow things down. If you're like, well, when did this happen? They're like, I really can't, I don't know. You say, okay, well, did it happen in the spring? Was it 6 months ago? Was it 10 months ago? And you, by prompting, you can sometimes help narrow it down. Even if they can't say a specific date, you can get some narrowing of it. And then, of course, at the end, you need to go into that retaliation. Explain retaliation is not allowed against them, and also that they are not allowed to participate in retaliation. All right, and let's see here. And then, again, I said that manage expectations is a overarching theme. So you want to, give an overview of the investigation process. For complainants, you want to kind of give updates, sometimes depending on how long your investigation is taking. Invite people to contact you if they have any follow-ups. And then one other major thing is to remember that both the complainant and the respondent have rights. So I think we have a likelihood to remember that you can't retaliate against the complainant, but don't forget that the respondent also has rights, that there could be litigation if you really mishandle it. Likelihood, As the slide says, it's increased over the last 10 years. I haven't seen that many of them, but it is possible. So that's just something to keep in mind. We've kind of gone over these interview strategies, but just approach your interviews with an open mind. Make sure that you are asking all of your questions, but also fully listening. And then the last thing to consider is to not make, well, not last thing of this presentation, but for your findings, don't make legal findings. It's all about personal policies, because remember, this can be used in a legal proceeding down the line. So you want to talk more about, this action X was a violation of this policy A, not that it was sexual harassment under Title VII or whatnot. It's you're making a finding that the policy, your specific policy, was violated. And then, as I said, approach an investigation with an open mind. Avoid appearance of result-oriented investigation. So appearance that you are just looking to get Bob fired. Avoid that. Discretion, you already talked about that. You can't do complete confidentiality, but you can be discreet. And then if you're recommending disciplinary action or some other kind of action, look for consistency, because again, we're going back to civil liability. If you're inconsistent with how you met out discipline for the same behavior, that can in itself look like retaliation or discrimination. So if in a prior case someone sent inappropriate sexual memes to an employee and they were terminated, that should be what you should do if it happens again with a different person versus, oh, well, in this case, we'll just give them a verbal warning. You need to be consistent. Again, as I said, you can investigate things that come up during an investigation that you weren't previously aware of. If it's something that is really an offshoot, you should do a separate investigation so that you can conclude one, make sure that's handled, deal with that complaint, all of that, and then go into another investigation. When you're making your conclusions, look at whether or not the witnesses were credible, and if you have everything that you need to know. And then when you're determining the outcome, so whether or not discipline is warranted. If you have reasonable evidence, you go assess the severity, you look at your policies, you again go back to consistency, what has been done in the past for the same kind of behavior, and then you document the disciplinary action. If you determine that actually nothing violated your policy, then you tell both the complainant and the respondent that the results do not support the complaint, and then reiterate the policy to the respondent if applicable, and remind the respondent that even though the complaint was not supported, that retaliation is still not allowed. So even if they feel, yes.
I have a question from the attendees. Are we required to disclose the witness's name when we are writing the notes? Can we use a phony name to protect the individual in case of open records request?
I would not suggest using a phony name. I mean, I think that'll look bad, like a pure phony name. I think it would matter more.
And what they said was witness A, witness B, something to that effect.
Well, I mean, you're probably going to have to at some point have some key of who is the witness A and witness B. So I don't think it's impossible. It's possible to get completely around this, because again, you want to have good documentation. I'm trying to think of when I would be comfortable with that, and I don't think I would be, just because it's going to look.
Well, if you think of potentially something else, we can send that out. And
Yeah, I'll think about that. I'll do a little bit of research and poke around. I just think that in order to have good documentation, you're going to have to use names at some point.
Very good.
All right, and then I think that's the end of, and are there any other questions?
Does anybody else have any other questions? Great question, Maria.
I'm sorry I ran over a little bit.
No. You did great. Anyone else have any questions? Anyone just want to talk, get an autograph? No? Well, thank you guys so very much. Thank you, Megan, for your presentation. Great job. And again, as I said, I will be sending out this presentation along with the recording and potentially some other information. So thank you so very much. Enjoy the rest of your day.